Legal 114, we move on to discuss spousal support, what we call maintenance in Illinois, and marital property. And I may have alluded to the fact that spousal support, like marital property, they're often negotiated items that ideally are negotiated as part of a settlement that helps both parties move on. Likely, both individuals feel like they took a hit on either of these things. But unlike child support that's required and very definite, these two items come with a lot of give and take and many factors and variables. Big items of property like cars and houses require parties to take into consideration equity versus debt for those properties in most cases. Most of us, until a certain point in life and maybe never, are always going to have to consider the debt versus whatever equity we have in those big ticket items in life, typically our homes, real property, or vehicles, unfortunately, because vehicles, I think there's probably if I went out and bought a new version of the 8-year-old 100,000-mile vehicle I drive every day, it would be in the range of the first house I ever bought, 91 or whenever that was. So vehicles are big ticket items. And because of that, it often comes down to not only who may want a particular item, but also who can afford to keep or pay for the right to keep that property. As discussed in the past weeks, spousal support isn't required. It can be waived or traded off for other property considerations. More equity or the entire marital home, etc. And I'm not going to get to or lump in retirement, but retirement, you should read that statute, and there is an expectation that someone could seek as part of their marital property, a portion of a party's retirement. Over time, what we've seen is that more and more people have retirements that may equal out or become more of that analysis that's similar to that income analysis in child support, or how we get to child support. And there is definitely an analysis, a calculator, and calculators you can look at regarding maintenance or spousal support. There's a way that we come up with, and the statute, as you've read the statute, I know, right, gives you that formula. But I think the main point should be that this is something, both of these areas that ends up being negotiated in many cases, not necessarily based on even the personal aspects, but because of the realities of people's lives. Now, if you recall what I believe I said weeks ago about typically my first bit of advice to people going through a divorce is to try to view it as if they would be splitting up a business or a business partnership. It really should, make more sense if you do this. At the end of the day, that's where it'll end up. Emotions, hurt, anger, all of those things, they don't show up in dollars in the final analysis of how the marriage ended and the property was split. They only show up in legal fees and further, I guess, misery for the parties. Now, this is especially problematic in my personal opinion at my stage in the game, and I've shared that my professional experience is limited these days to doing some clinics, typically in family law cases for Prairie State Legal Services, and it's always been my position, and based on the mentorship of lawyers who came before me who were experts in family law, things that I was taught. The late John Pusey is an example. John was a tremendous family law lawyer who taught family law at the college, taught the night class to my day class, and primarily I recruited him to teach because he's one of those people. I mean, he's the person who uh, advised me when I was a young lawyer that you shouldn't expect people to become more reasonable in the midst of a divorce than they might be before the divorce. If they were, um, the couple likely wouldn't be in that position. If the people were able to find that place of being reasonable with one another, then they would have figured out a way to work things out instead of blowing up their lives. And um, all the emotions that you see and we've talked about, those emotions, in addition to kids that we've just finished talking about in the prior week, they come up in this property area. Um, the spousal support, more so when you have someone who had expectations of being taken care of, it seems to me, whether those expectations were valid or not, or and sometimes they weren't warranted, but that seems to be the case. But more so in that personal property division, I've seen people get very personal and emotional about certain things, and they wouldn't even be things that you would think would be worth getting all riled up about, or um, really paying a lawyer to fight about. And in fact, I remember at one point having a client who was very upset that the other person had removed, I believe it was a blender and a um, a toaster that had been received years before, like 10 years before, or whatever, how many years it was in a marriage. So if they had used either of those things, especially a toaster, I would think that the toaster was probably at the end of its life. And at some point, because it was such a holdup, I think I offered to take them to Target and buy them those items, brand new, better probably, as a point of emphasis as to just how ridiculous it had become to cling to those things. And it was more out of emotion or anger or whatever because their circumstance was changing. This is an area that you probably, as a legal assistant or paralegal, if you're serving in that role, will deal with clients on a one-on-one basis more often than the lawyer. The more emotional someone becomes, the more emotional your client becomes, the more they are likely to spend on legal fees, probably being dissatisfied with your representation because they're just going to be paying you more to fight battles that they conjure up. Um, the more emotional they become, the more emotional it becomes for the other party, the more expensive it'll be for our client, causing them to spend money on legal fees, probably being dissatisfied with our representation because they're having to respond to the other party then becoming emotional. Ideally, and my favorite lawyers in this area of the law, and there are some people that are still practicing who I respect very much, people I consider mentors. Um, I respect them because they practice that Abe Lincoln philosophy of there will always be business enough, and when there's 50% of first and second marriages ending in divorce, there's always going to be enough divorce business. They saw it as their role, or they see it as their role, to try to find some sort of resolution that causes the divisiveness to go away with the marriage. And hopefully, especially when there are children involved, allow the two parties to peacefully coexist as to those children. And even where children aren't involved, allow those parties to coexist within the same community or what have you without animosity. Let them go on with their lives. And that is, by the way, if you remember from our ethical considerations, the Code of Professional Responsibility, and all the things you've studied in this and various classes regarding our ethical obligations, at the end of the day, that is our role. As Lincoln said, the lawyer as a peacemaker. He didn't say the lawyer as a litigator who goes and tries to further cause people to have, a hell of a ending to an already sort of divisive and untenable relationship. But at some point, that's just the way it is. So we, as the legal services professionals, have to have thick skin and accept that the best way we can do things is to figure out how to calm the client, to minimize unnecessary legal fees and split assets as equitably as the law allows to the best of our ability under the circumstances. And we have to guide our clients to do that. And I make that business analogy because this is true whether we are assisting in the dissolution of marriage or dissolution of a business partnership or LLC or corporation. When partners in a business break up, property, debt, and equity, and who gets or is responsible for what those things are, those are the only issues. We solve those issues and the parties can, in theory, move on and be free from one another. Now, to be clear, I've seen business dissolutions, and remember we call the breakup of a business dissolution, just like we do with divorce or the end of a marriage. I've seen those things get just as emotional, and people spend money out of spite, waste money out of spite. And I've seen lawyers in that arena just as I see lawyers in the family law courtrooms, thankfully few of them, who are more than happy to take people's money without a care as to the dissension they create in their lives or the animosity they create between them or anything else, just focused on their fees. Again, far and few between. But again, that's not our role. It's not our ethical role. It's not my ethical role as a licensed lawyer. If you become a licensed lawyer, it won't be your ethical role. And if you work for a lawyer, it's not your ethical role. Now, dissolution of marriage isn't always easy, especially if the parties have children. Children create a bond that connects the two divorced individuals for their lifetime. I've explained that to people more times than I'd care to because they get focused on the here and now, the moment, how much child support they're going to get, whether or not the person brought the kid back on time, whether or not this or that. And they think at some point, when the child turns 18 or whatever, they won't have to deal with the individual. But here's the thing, you're always going to have to deal with the other individual if you share children to some degree. And it can sometimes become emotional and contentious. Ideally, again, in that area, we try to get the people to see that because they continue even after they've fulfilled their obligations regarding the child or the child reaches the age of majority, they continue to have to deal with one another. That also has, an impact on those cases where we have kids in how we should view that overall package or settlement options um, when we're talking about spousal support and division of marital property. But at the end of the day, the reality is that for parties of a divorce, the property aspects and responsibilities for money sought from either party beyond child support is going to be a matter of determining debt versus equity of each asset at issue. It requires assessing the value of those assets and the desire of one party to receive and another party to be willing to give up those assets. It requires acceptance of the ability of the party that wants the assets to either pay the other person or obtain financing to pay the other person for their share of the equity in the asset, a home, for instance. It isn't uncommon when, especially when you have minor children, that one party wants to stay in the house, typically the party that's going to have primary time and responsibility for the children. But that other party who's leaving the house, the marital home, is going to expect to get their share of the equity. And so it becomes an item that at best is negotiable and has to be dealt with. Where child support and other issues like, a determination of the maintenance or spousal support amount can be more easily determined because the statute provides some sort of formula, some expectations. Marital property isn't always that easy. It can be extremely frustrating for you, the lawyer, the client, as negotiations proceed. Um, as I, you know, as I think I've tried to share, it goes back to that reasonableness aspect and how reasonable people are or are willing to be. The entire apple cart can be upset by one party or the other changing direction or where they wanted to go, or wanting more assets, or getting emotionally upset about some particular issue that has nothing to do with those assets. And more often than not, you or your supervising lawyer may find yourself reloading that apple cart, helping pick up the apples, getting things reset. Now, if you practice in this area of law or even a business area of law that deals with dissolution of businesses or formation, which always includes some sort of change in that business at some point, you have to be prepared to follow the process. Be prepared to create, update, and accurately redo your asset inventory. Have it updated and ready at a moment's notice. You have to have thick skin. You have to accept that clients may be disgruntled, emotional. They may even be rude because they're caught up in the emotion and they have often experienced trouble letting that emotion go. And you can't react to their emotion or any accusation by the client or opposing lawyer or party. You just work with the lawyer, your supervising lawyer, to come up with both what your client should reasonably expect and then how to best get to that point. Now, again, there doesn't seem to be any rhyme or reason, doesn't seem to be any rhyme or reason. And you have to keep some realistic expectations. For me, in my experience and the advice that I seem to give more often, if you had a person who was willing to, one of the parties or the other, and sometimes it's both, they're they're inclined to infidelity, whether that's with another person, whether that's financial infidelity, which sometimes it seems can be worse than infidelity with another person. If it's just a lack of care or they change direction and what they want out of life and they make the left turn without warning and don't tell anybody, you're going to be sitting there and helping people navigate through that traffic accident, that crash of the marriage. And there isn't always logic behind it. There isn't always some reason. Um, Only that other person knows the reason. Now, if you're representing the person, that other person, the person who is kind of creating circumstances that may have contributed to more than the other person, the result of the end of the marriage, and that person isn't being reasonable regarding their expectations or what they're trying to do to create further dissension or pain for the other party, that individual is your client, well, then the lawyer, I think, is obligated to sit the individual down and say, well, here's what the law allows. And yes, you might be able to delay, frustrate, continue to treat this person poorly. And maybe they wear the other party down. My view is you go back to your ethical obligations, the code of professional responsibility, and that's not what any lawyer should allow. So it should be something you should note and make sure your lawyer knows if you're not the lawyer, if you're working for a lawyer who's representing somebody in one of these cases. Ultimately, to wrap it up, spousal support or maintenance, there's a formula. Uh, you figure out what the formula says the likely maintenance would be for the amount and numbers of months. It's based on the amount of time the couple was married, as you've seen from the statute. But then, again, that can be negotiated. As far as the other property, the house, if somebody wants to stay in the house, um, the other party's entitled to their equity out of the house. So you have to try to figure out, or that person who wants to stay in the house has to figure out how they can pay out that other person and then keep the house. Vehicles, typically, the person who wants to keep a particular vehicle, if there's a loan on that vehicle, has to assume the loan. Vehicles usually work out in that respect. Other debt and bank accounts, etc., plus all of the personal items in the house. They have to be inventoried. You determine all the things that you can remember when we discussed property in wills, trusts, and estates. The status of that property, real, personal, how it's held, if there's a title, whether it was held before the marriage, whether it was commingled into being marital property, the whole thing. And then you figure out the value of it and you do an inventory and you have an idea. A lot of times people sort things out. They sort out all the personal property, pieces of furniture, things that they brought to the house. That doesn't necessarily mean if they brought it to the marital home that it has remained their property. But they work a lot of those things out. And then sometimes people have the most ridiculous clinging to personal items that, as I said, I could take you to Target and we could buy updated, better, not 10 or 15-year-old version of that toaster. That's spousal support or maintenance and marital property. It's also the conclusion of section 5. Yeah, I believe. And, or is it 6? Holy cow, it's 6, people. Section 6. We only have 2 more sections of this class. Keep up the work, especially as conditions outside and springtime pops. We only have a few more weeks, so dig deep. I know it's a lot, but you're doing great. And if you need me, you know where to find me.